Alrighty, this We the People News. One more time at it. Not attorney, not giving legal advice. Educational purposes only. Okay? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Use the Second Amendment. Arm yourself with knowledge. Okay? And we're going to, I believe this is going to be the last one, but let's play it by ear.
Work decay. All right, Kirk, you may continue.
All right, thank you, sir. Just wanted to again elucidate that there were 3 officers present when Officer Jantz had me get out of the car. Reached into my car window, which was locked, and he unlocked it and opened my car door. Back to Hale versus Henkel, we do not have to open up our doors. We have no duty to the state. This is back to like the Gestapo's papers, please, papers, please. We went to war over that kind of stuff several times. Another one that I would like to talk about is, being heavily armed with 3 officers present. So we have 2 or more that are.
You were armed or they were armed?
They were armed.
Oh, okay.
Heavily armed, wearing bulletproof vests. And
this was clarifying, Kirk. I just need how you said it. I was not clear where you were.
Sorry,
no worries. Fine.
You want to create a good record here.
I appreciate
and
that.
full understanding. That's where he put his handcuffs on me. There was 3 officers present, so this where we get into deprivation of rights while acting under color of law, where 2 or more go out on the streets and highways in disguise. That's 18 UFC 241 felony. And if it involves the attempting kidnapping or attempting to kidnap, which I'm claiming I was kidnapped because I was taken somewhere where I didn't want to go, inside of a building, and forced through all sorts of cruelty, because I exercised my right to remain silent under the Fifth Amendment, not answer any questions. They immediately threw me in three of them, two men and a female officer, sheriff deputies. 2 of them physically grabbed me while I was handcuffed and forced me down the hallway into a small concrete room cell with no blankets, no pillow, no toilet paper. Forced me down on the concrete block pad there. Stripped me of my socks, my shoes, basically all of my clothes except for my shirt and my pants. And the temperature in that room was extremely chilly. So this is part of torturing techniques of, also called like dieseling. It's a form of torture to basically, torture me because I'm not cooperating with them, and they feel like that they're justified in doing that. But I shouldn't have been there to begin with. It should have been brought right here before a magistrate and then made a determination. Everything that's going to be should be determined here today in the interest of justice, which justice is supposed to be without sale, denial, or delay. Clearly, justice has been delayed already in this case from its inception. But that's what I was subjected to for over 2 hours in there. And finally I said, okay, I'll answer your questions just to, get out of being tortured. And it wasn't about the photograph, taking pictures and fingerprints. It was right from the very beginning asking me questions in there, which they call their booking process, which again violates due process of law, because not even supposed to be there. And the taking of pictures and fingerprints and that kind of stuff, have to have a warrant for that. You're seizing information, my personal information from me. That violates the Fourth Amendment. It doesn't follow due process of law, and obtaining a warrant for that information connected with some sort of a crime would be completely irrelevant in this situation. What would they need my picture and fingerprints for? Would be completely illogical to even begin to think they need that kind of stuff. In regards to like handcuffing and searching, that kind of stuff, Terry versus Ohio established the standard for stop and frisk. Handcuffing is generally outside the scope of a Terry stop unless necessary for officer safety or to prevent flight, which we just submitted in the police report there, that there was no resistance, no physical resistance at all. So there was I was no threat to his safety, which kind of goes contrary to what government was instituted, was to secure our safety, not their safety. That's in their line of duty there. It's like saying, going into war and military and, well, I got to do this for my safety. Well, we don't do things as an officer doesn't do things for his safety. He does it, right? Of the people, by the people, for the people. That's the fundamental principle of our republic. The government was instituted to secure our rights. So, not the other way around. That's just the risk you take when you take that kind of job. Graham versus Connor, claims of excessive force are evaluated under the Fourth Amendment's objective reasonable standard. And clearly this was not reasonable based on his own statement in the police report. There was no violence. Wasn't attempting to flee. It was in cooperation with him, and which we will see in the videos there. Let's see, use of handcuffs during detention in the United States versus Hensley. Investigative detentions involving handcuffs must be justified by concerns for safety or other exigent circumstances. Again, back to his own statement in there was no exigence or anything worried about his own safety. Excessive force cases, there's a couple other cases from the 10th Circuit, the 5th Circuit. Fisher versus City of Las Cruces found that unnecessary tight handcuffing causing injury could violate constitutional protections, and prolonged unjustified handcuffing constitutes an unreasonable seizure, which I had to sit in the back of the car handcuffed for over 5 minutes, plus the time it took him to transport me to the Ada County Jail. And the whole time I was incarcerated there, unlawfully kidnapped, being held against my will, handcuffed, until they put me in the cold cell, stripped me of my socks and shoes and clothes, and tortured me for a couple of hours. Of course, there's Idaho-specific case law here. State versus Bishop, State versus Henderson, Tackett versus State of Idaho. This is 1988 is the Henderson case. 2009 was the Bishop case. 2011, Tackett versus State. Emphasizing
the case law you cited real briefly, Kirk. On page 9, or excuse me, page 13, you cited State v. Christensen, 144 Idaho 463, for the warrantless arrest must meet the probable cause standard and adhere to statutory guidelines. When I pulled and reviewed State v. Christensen, it appeared to be a case involved a trial issue regarding an arson, so I wasn't sure what you were referring to.
So the particular case he's referring to there, blah, 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 I didn't have in front of me, and I actually misquoted that case. And when I got home, I looked it up and was like, oh, crap, that was the wrong one. So, but notice, this is the only thing out of my 25-page memorandum of law that he could pick apart.
Which is kind of funny because that's what they do over and over and over. The prosecutors actually give false cases, and they don't usually read it, and it don't apply. For Alphonse on his tax case, right? I can't pronounce his last name, but I've done videos of Alphonse, right? He was battling tax cases. Well, that's what they did. And the judge used that as justification by the claimant at the time. Well, it was a lawsuit, so no, it wasn't. It was still the county going after him. Anywho, in order to lose that case, the attorneys used a case that did not apply to them, and the judge used it to weasel himself out of it, and the case was dropped, basically. So Alphonse has got to go through there and figure out what he's going to do next. But that's what they do. So you guys be real careful with the other parties there, because they will use cases against you and the judge will uphold it. But they won't do the same for you. You got to be on point, especially when you're pro se, sui juris, or any other name. But if you represent yourself in any form or fashion, you got to be better than attorneys. You got to box them in.
Everything else has all been verified by him, because listen to what he said. Oh, I was reading and this one case, just one. See, this is what they do. They go through all of that, everything that you file. Okay? And they're looking for any errors that we make, especially as pro se litigants. They don't really do that to the other side. They want to try and pick us apart. So, again, I want to reiterate like something that Carr Miller was talking about, is if you're going to...
Again, we're on the same page. Again, timing.
That case, you better read the case. So, this would have been my faux pas there. And actually, that particular case actually got that from AI. Said, hey, give me some cases on probable cause arrest or whatever for Idaho specific case. And so that's one that came up. And I should have just used the one that the the prosecutor already cited in their previous objection to the motion to suppress the motion to dismiss, because they cited it and it said what I needed it to say. And I thought about doing that. I just didn't get it in there. I could have just stole it from them, but nonetheless, it's still in the record. Their own objection. Well, that's the right of the people, right? And that's, again, misinterpretation of the Fourth Amendment. They say, well, it says the right of the citizen. No, it says the right of the people. But it just basically is you got to have probable cause of a crime, right? And that's where I did use AI for quick searches type stuff and formatting type stuff. But as for writing my paperwork, that was me. I write my own paperwork. So, I mean, that's pretty much the end of it right there. But it's about doing the paperwork and the oral argument. We have to be able to.
And we had to go with this step further. So even if you use AI and you court case, it may look interesting. You can go down to, most cases, you can go down to the courthouse and type in that court case, and they have Westlaw, okay, which I can't afford. That's like $400 a month, $500 a month to use that. But they got case laws in there that most others don't have. All right, and but to pay for it every single month is $400. It's specifically designed for attorneys to use, and not for the average people. And but if you got the money, get Westlaw, especially if you're going to be a sui juris or pro se, right? So take that with a grain of salt. I had to take up a case. The only way you can find a tax particular deal for New Jersey, saying that, in short, that the county can't tax people unless they have some form of nexus attached to it. Okay? So I went to Westlaw, but I had to go down to the courthouse to go to their library and look up that name so I can pull it up and read it and see if that would apply. Okay? It did apply, but they ignored it. Of course they did.
But we have to articulate this stuff. And one thing that I learned from the previous case is the motion to suppress is, in essence, where we do the constitutional challenges in the very beginning of the case, because if they violate any of our rights, that's grounds to suppress all evidence for being unlawfully obtained. So, and that was, and actually, I knew about the motion to suppress, but I didn't realize that that's the way that's supposed to be done, what that's used for. I was just used the motion to dismiss. But when my brother Peter over here, when we went down to go witness one of his motion to dismiss hearings, when we got there, they were in the middle of a motion to suppress hearing for a woman, a DUI, who they put handcuffs on her, and they were suppressing all the evidence of being illegally obtained because they put handcuffs on her. And I'm sitting there listening to this, and I'm like, well, crap, we can damn near beat every single case because they always put handcuffs on us. So there's a nice little tidbit for everybody out there. Motion to suppress, if they ever put handcuffs on you, excessive force, you're done. Violation of the Fourth Amendment. So, just one little piece for you. Piece of information, very, very good information.
All right, and I'm gonna go through the rest of this and maybe another one, because it didn't sound like that was the end of it, but it may have been. But I thought that was interesting as well. So I'm gonna have to kind of listen to what he just said and kind of sink it into my brain about that. Huh? You guys out there as well? Just with the People News. Bye, y'all.